to our Conducting Effective Investigations virtual boardroom that's been facilitated by HR Recruit and Nathan Andrews. My name's Jo Thompson and I'm a consultant for HR Recruit. I'm joined today by Nathan, who will introduce himself shortly. Nathan will be drawing on his professional experiences of conducting complex workplace investigations to share tips and best practice in this session. If you've got any burning questions, please put them into the chat box facility and we will cover them at the end. I'm now going to hand you over to Nathan, who will introduce himself and start the event. Thank you.
Thank you, Joe. Hi, everyone. Good afternoon. As you know, my name is Nathan. Some of you, or most of you, may have been on previous webinars that I've done with Joe before. So if you've met me before, kind of, albeit virtually, via a webinar, it's nice to see you again. And as Joe has said, we are going to be covering off conducting investigations into workplace matters. So I spend a lot of my professional life dealing with complex investigations. So I'm currently the head of HR services at Frettens Solicitors. So I head up the team that provides HR consultancy services to our clients. And our core services are focused on HR case management, the conduct of complex workplace investigations, and mediation and conflict resolution. So I spend a lot of my time supporting organisations with complex workplace matters. And I am a trained and accredited investigator. So I draw on my kind of not only my professional training, but then my practical experience in this area of work. So if I start off with what we're going to cover, I'm just going to make my slides a bit bigger so I can see. So what I want to cover off with you today is launching an investigation, considering HR's role in the investigation process, how we as investigating officers, or if you're not the investigating officer, so perhaps you're an HR representative supporting an investigating officer with an investigation, is talking through how we should approach the investigation process. I'll cover off suspension during the investigation process, what happens if the police are involved, maintaining confidentiality and protecting identities or witnesses, holding investigation meetings, questions for the investigation meeting itself. So that will be about developing your line of questioning. So that's a really important aspect of the investigation process. And then we'll draw on the investigation report itself, which will be something that you would work on at the end of your investigation process. So to start off with, I want to talk about launching an investigation. So I always say it's an important point to remember that, which can often be overlooked, is that not every issue will require an investigation. So depending on the nature of a matter that you're dealing with, it may be that you don't need to conduct a full investigation. To put that into context, it may be that you have received some feedback from an employee who has given voice to the fact they have frustrations in their working relationship with a line manager. It may be that actually that doesn't require you to conduct an investigation. It may be that you need to sit down with that individual and give them some specific feedback, and you may make records of that conversation you've had with that line manager, but it wouldn't necessarily be that you need to go away and do a full investigation. That being said, it could be that actually the concerns raised with you form a pattern of behaviour that you've identified, and it may be at that stage that you want to conduct an investigation. But what I always say to my clients is, let's look at the issue in hand and let's make a decision about, do we need to investigate? Most typically, if you have an employee who's raised a grievance, yes, you would need to investigate that. If you're dealing with conduct issues under your disciplinary procedure, then absolutely you would want to investigate those issues. But it's just taking a pragmatic approach. Not every issue is made equal, and certainly wouldn't necessarily require you to conduct a full investigation. That being said, if an investigation is required, I always advise that you should formulate a detailed investigation plan. Now, this is something I find certainly with the clients I work with, this can often be overlooked, because when clients come to me with a particular issue, often they feel the kind of pressure in terms of getting started and looking at what they need to investigate. And what I always say is actually the best piece of work you're going to do will be the investigation plan, because that will set out the framework that you're going to follow for the remaining part of the investigation process itself. So a really good investigation plan should set out who the investigating officer will be. You want to identify that person, name them in your plan. It should clearly set out the terms of reference of the investigation. What I mean by the terms of reference is, what are the issues that need to be investigated? You want to be really specific with your terms of reference. You want to clearly set out the issues and the issues that need to be explored as part of the investigation process. Another important aspect of your terms of reference is to make sure that you can draw on those terms of reference to develop a line of questioning, and we'll come on to that a little bit later. But it's a really important piece of work. Again, within your investigation plan, a provisional timeline is essential. That gives you something to work towards. You want to identify any relevant company policies and procedures which are going to apply to the specific matter that you are investigating. So that's really important as well. So it's quite front-loaded, the investigation planning stage, but if you do it right, it will make the investigation process itself much easier to manage moving forward. You also need to be clear on the issues which need to be addressed. So you need to think about the questions you need to find answers to. That will again help give you a framework for your line of questioning. You also want to think early on at the planning stage about the types of evidence which need to be collected. That might be things like witness statements, CCTV footage, copies of documentation. So that could be emails, for example, letters sent from HR or letters sent from line managers to employees concerned. It could be things like gaining access to IT logs. All of those things you need to think about, because actually there is often logistics around gathering that information. CCTV footage, you may need to speak to IT or another person within the organisation. Certainly with our IT access logs, you'll need to speak to IT to gain access to those, and then you'll need to sit down and spend time reviewing those and understanding the data that's contained within. So again, planning early on will help you set out a clear kind of timeline of how long you think it's going to take you to conduct that investigation from start to finish. You also need to think about the people who will need to be interviewed, so identifying your witnesses. You want to speak to the complainant, you want to speak to the respondent, and anybody else they identify during your initial meetings. But it's really helpful to set out early on who do you need to speak to, and making sure you're planning those meetings proactively. And that being said, it may be that as you investigate parties, you will identify other individuals you may need to speak to. So your investigation plan is very much a working document. You will add to it as you work through the investigation process. But you do want to have a finalised draft that you're working from before you start the investigation process, because again, that will help you plan out the investigation and all the relevant aspects of work that need to be undertaken. As I say, often people say to me, the investigation planning phase seems like an onerous process, but actually it's so important to get the planning right so that you can make sure that you do the investigation itself justice. You want to produce a defensible investigation outcome report. And the best way of doing that is being really organised and being really clear on what it is you need to do as part of that process. Now, Joe, just quickly check, are my slides moving on your screen? Everyone give me a thumbs up.
Yep, they're
Yeah,
moving.
perfect. My screen froze then, so I just want to check. Okay, so I just want to talk about HR's role in the investigation process. Now, HR will often act as a background advisor. So if you have a line manager who's handling an investigation into, say, a conduct issue, for example, with one of their employees, oftentimes as HR practitioners, we will all know that we'll act as a background advisor, and we will be advising the line manager on process and procedure within our organisation. We'll be signposting them to our policies and procedures and making sure that whatever they do as part of the investigation process, they're not deviating from our HR practices as an organisation. So that's really important. The alternative situation is where HR, or as an HR practitioner, you are leading on the investigation as the investigating officer. So it's really important to be clear on those two distinct roles. If we're acting as a background advisor, it's important that we allow the investigating officer to do their job as the investigator. It's for them to go away and do the fact finding and to set out their findings from the evidence they gather. It's not for us to apply undue influence on that process. So we need to make sure that we limit our role to advising them on points of law, so points of employment law, and points of process and procedure. That's particularly important. Obviously, if you are leading on the investigation as the investigating officer, then it is your investigation. You are responsible for the conduct of that investigation itself. But it's something I stress, and I think it's a really important point. What you don't want to do is to leave yourself and the investigating officer, and when I'm making these comments, I'm talking about the scenario where you are acting as the background advisor, as an HR practitioner. What you don't want to do is to do anything that gives rise to either the respondent or the complainant suggesting that actually the investigating officer was heavily influenced by the HR team or the HR practitioner responsible for HR within the organisation. So it's something just to be guarded against, and I say that intentionally. It's very easy when we're acting as background advisors to want to make sure that everything is done properly, and we will obviously have a particular viewpoint. We'll have lots of awareness around custom and practice, for example, in dealing with other issues. So it's making sure that we advise on relevant areas that are important to the investigation process, but we're not applying undue influence to the investigating officer in terms of their findings, etc. So, approaching the investigation itself. So, a good investigating officer will be thorough and considered in their approach. They certainly shouldn't adopt a fly by the seat of their pants approach to the investigation. That's often helpful. It will, normally result in an investigation that's not been well thought through or not been well planned, and things can get missed. So, it's really important that the investigating officer is organised and able to plan their time accordingly. And this is where your investigation plan will come in. If you have a good investigation plan, that will enable you and the investigating officer to essentially form a checklist or a to-do list of tasks and actions that they need to complete as part of the investigation process, and they can essentially go through that list and tick them off one by one. So it keeps them very much focused. I always advise, if I'm advising as a background advisor and investigating officer, I always say to them, get clear on your terms of reference, be really clear on what questions you need to answer, because that's the whole point of an investigation. There will be a series of questions, and we need to establish facts and find answers to those questions. Having an investigation structured in that way will help avoid going down rabbit holes. And I think that's really important. It's very easy, and I see this a lot in the work that I do when I'm acting as a background advisor, where investigating officers, they kind of go down rabbit holes, and the investigation itself becomes broader and wider. And actually that can leave you exposed to criticism or claims that there was a witch hunt or there was an intention to find wrongdoing on the part of the respondent. And often that's not the case. It's just that through maybe lack of experience or training, the investigating officer has gone down a rabbit hole, and the investigation has become much broader than than it needed to be. So having an investigation plan, having clear terms of reference is very important because it helps prevent that from happening. Okay. As HR professionals, it is our job to meet with the investigating officer and to make it clear to them the extent to which we require them to investigate any issues, to interview staff members, and essentially to test the evidence that they find. So that is our role. So early on, when we know there's an issue, we're going to essentially instruct someone to conduct an investigation, is making sure that those parties who are commissioning the investigation itself, they meet with the person who's going to be appointed as the investigating officer, and we give them clear guidelines and instructions around what the issues are and what needs to happen as part of the investigation process. That being said, it's their investigation, it's for them to manage, but it's giving them a clear framework of what we need them to do, and then they go away and they do that. So I think, again, the investigation planning phase is really important and will be really helpful to the investigation process itself. Now, as we will all know, if for any of us that are working as HR practitioners, the word is always reasonable. The investigation process must be reasonable. That's essential. We should inform the employee that an investigation is taking place. So that is largely going to be the respondents. If you're in a grievance scenario, for example, or if you've got somebody who there have been allegations of misconduct made against them, we need to inform them that those concerns or issues have been raised and that we are going to conduct a formal investigation in line with our policies and procedures. We should absolutely adopt a reasonable time frame, and that's why I always say in the investigation plan itself, you should absolutely set out a provisional timeline. That timeline will be subject to change because as you work through the investigation process, as you interview witnesses and as you gather evidence, it may be that you uncover other areas that you need to explore, other issues, other witnesses that you need to interview, and it may be that your timeline will change. And that's perfectly normal if it does, but it's making sure that we capture that in the investigation plan, we update our timeline, and we update all the parties who are involved or subject to that investigation. So it's really important that we adopt a reasonable time frame. We don't want there to be unnecessary delay, notwithstanding that we may change the timeline if we need to do extra investigative work, but it's about also making sure that we keep parties informed if that happens. Following internal procedures, I've already talked about this, but again, I will touch on it for completeness. Really important we don't deviate from our policies or procedures unnecessarily, as that will leave us exposed to criticism. And so we want to avoid that at all cost. Establishing facts is really important. So a good investigator will look at the allegations or the issues that they are investigating, and they will gather evidence and make sure that they establish facts around those issues. So that again is important. You also want to avoid confirmation bias in the investigation process. So appointing somebody who is neutral and impartial is essential, and you also want to be mindful of confidentiality. And I always say that I certainly adopt the approach when I'm acting as an investigating officer that I will only share information on a need-to-know basis. When I talk about confidentiality, so when I have touch points with individuals, if I'm interviewing witnesses or meeting with a respondent or a claimant, I explain to everybody I speak to that the investigation process is confidential, that nothing discussed in meetings should be discussed with anyone outside of that meeting. And I also remind parties that if it were found that they were willfully breaching confidentiality, it could leave them liable to disciplinary action themselves. I always share that intentionally, and I make sure that's recorded in any documentation as part of the investigation process, because I have been in situations where confidentiality is breached. It then gives rise to complaints from respondents, for example, who may say that actually the investigation was compromised. People went and discussed confidential information, and that can give rise to further grievances. So I want to be able to be in a position that if that happens, I can address that with the issues with the parties concerned. So it's really helpful if you manage people's expectations early on. So during the investigation process, it may be that you need to suspend a respondent because of serious allegations being made against them, and so suspension should only take place if necessary. And what I mean by that is that you have good reason for the suspension itself. There used to be, people used to hold an opinion many years ago when I started out in HR that if you were contemplating maybe dismissing someone because there were allegations of gross misconduct, for example, that you should suspend, and not suspending could be unhelpful to any decision to dismiss. Thinking on that has changed, and that changed some time ago. And actually now the thinking is that you should only really suspend if it's absolutely necessary, and you should look at alternatives to suspension. So, for example, if I think I'm dealing with something that may require someone to be suspended, I will look at other options first. Can I move them to another department? Can I get them to not take responsibility for a certain aspect of their job whilst we're investigating? The things that I will think about, and I'll capture my thought process and document it. So if I do reach the decision to suspend, and I'm talking about when I'm acting as a background advisor, so I'm working with a line manager, I'll make sure we've got clear records of why we made the decision to suspend. For me, suspension normally is always if I feel that allowing the employee to remain in the business while we're conducting the investigation could compromise the integrity of the process. It could put evidence at risk of being tampered with, or there could be risk of witnesses being intimidated, for example. So those are the things I think about if I'm going to, advise that we may need to suspend an individual. So that's something to think about. But again, just to reiterate, I always make sure that I document my rationale, my thinking. When I work with clients, we have a suspension risk assessment document that we use, and we go through that with our clients just to make sure that any decision to suspend is defensible, and that we can justify our position or decision making in that regard. So just to cover off, if you do suspend an employee during or prior to investigation process, we need to make sure that, again, our decision making isn't draconian. We need to also confirm that in writing. So we need to be writing to the employee to explain to them that they are being suspended on full pay pending the outcome of the investigation. We need to make clear that any decision to suspend is neutral. It's an administrative decision, and it does not suggest that there's any guilt on the part of the respondent. It's purely to allow us to conduct the investigation process fairly and impartially. So again, really important that we make that clear to the individual concerned. So I just want to touch on maintaining confidentiality. This is something that comes up a lot for me in the work that I do with client organisations. Now, obviously, working through an investigation process, as we've already said, it is a confidential process. That being said, when I'm interviewing witnesses, I never guarantee that I can protect witness anonymity, and I do that intentionally because the reality is, if at the conclusion of an investigation it's found that there is a case to answer, and it may be that you are going to uphold a grievance, for example, and refer the matter to a disciplinary officer, or you're dealing with allegations of misconduct and you found that those issues are founded, and that, again, it should be referred to a disciplinary officer. Potentially you're going to have to release witness statements or notes from meetings to the respondent so they can adequately prepare their case. Now, there are times or occasions when I have redacted witness statements or notes from meetings to try and protect the identity of witnesses, but I've only done that in exceptional circumstances. The reason I never make a guarantee of protecting someone's anonymity is because for a respondent who needs to prepare their case, they will argue that for them to be able to prepare their case adequately, they need to know who's making accusations or allegations against them. And so if we are providing someone with a bundle of evidence that's completely redacted, that could make it difficult for them to be able to do that. So, again, I'm not saying we don't look at protecting identities or witnesses, but we should only do so if there's a genuine need for us to take that course of action. And I always, recommend to our clients that if they feel they need to do that, is to, contact us and take advice so that we can make sure that any decisions taken can be essentially objectively justified in the circumstances. So, holding investigation meetings, there's some things that we need to consider because these are really important meetings, and these are meetings where you're going to do the majority of your fact finding. So, things to do before an investigation meeting. Plan the questions which need to be asked. So this is really important. Developing a robust line of questioning is going to be really helpful, and again will give you the framework for your investigation meetings. That line of questioning should help you answer the questions or the issues that you are investigating. Or if you're acting as a background advisor, this is where, as HR practitioners, we can come in and support the investigating officer with this piece of work, because if you're not used to doing this piece of work, it's quite an alien concept. But developing a good, robust line of questioning will be essential to making sure that you have really valuable investigation meetings that help you uncover the issues that you need to address. You need to make logistical arrangements for investigation meetings. So things to think about are you holding them in person? Are you going to hold them via Microsoft Teams or Zoom, for example? Then we need to make sure that if we're holding them remotely, does the individual who you're meeting with have access to a company laptop, for example, or a computer so they can join the meeting room, and making sure that they are familiar with using things like Teams or Zoom as a platform. I always say it's good practice to write to attendees and to invite them to an investigation meeting. You're not obligated to do so. So, for example, if you're holding investigation meetings on site, there's nothing wrong with you popping down the corridor and speaking to a colleague and say, can I have a meeting with you, and inviting them into your meeting room and sitting down and running through a list of questions. You don't need to give them advance notice, and I certainly don't ever advise that you give people information in advance of that meeting around what you want to discuss with them, because it's much more helpful to the investigation process if you can meet with somebody and run through that information in real time with them, so you can capture not only their responses but how they reacted to questions, etc., that you were asking or covering off in those meetings. Now, I just want to talk about the start of an investigation meeting. So what I always advise our clients to do is to clearly explain who's present and why, so introduce everyone in attendance. You want to set out the purpose of the meeting. You want to set out the investigating officer's role, which is essentially limited to being a fact finder, not a decision maker. You want to cover off confidentiality and possible consequences for breaching. We've already talked about that, but it's a good reminder. You also want to talk about who will see the notes or statements from the meeting. So I myself will always say to parties that I'm interviewing that the notes from these meetings potentially will be shared with the parties concerned if it's considered that there is a case to answer and that the company needs to take steps to address its concerns. And you also need to make clear that the notes from the meeting may be used in the investigation report that you're going to produce. So if you're the investigating officer and you're capturing notes from a meeting, you're going to want to probably reference those in your investigation outcome report. And again, is making clear to the parties you're interviewing that that investigation report could be made available to the parties concerned, in particular a respondent, should there be disciplinary action that's going to be taken on conclusion of the investigation process itself. During the investigation meeting, questions should be asked which are focused on getting facts, really important. Probe, but not in an aggressive or adversarial manner. I think that's really important. You don't want to come across as being aggressive. I think that then people tend to pull up the drawbridge and shut down. What you want to do is engage with the individuals you're interviewing in a really meaningful way so that you can capture the most helpful, relevant information to your investigation. So I think that is really important. If the person you're interviewing refuses to answer questions, make a note of that. We can't compel people to answer our questions, but if they willfully refuse to answer questions, you can make a note of that. That is relevant, and you can refer to that in your findings when you're drafting your investigation outcome report. I always say look for opportunities to find evidence which can substantiate what is being said, and I think that's really important as an investigator. You want to be able to substantiate as much as you can what is being said to you. So looking for evidence or other evidence that can support any statements made by parties. At the end of the meeting, ask the person you're interviewing if they have anything else to add, or if they feel it's important that they mention additional information that they've not shared with you. That's really good practice. You can also ask if there are any other people they think you should interview as part of the process. So maybe they say, look, I've given you an example of X, Y, or Z, and somebody was present who witnessed that. You can capture that detail and then go and interview that party. You should also explain you may need to arrange a follow-up investigation meeting if you have further questions or if there's information you feel is missing. So it's just preparing them or managing expectations that maybe you want to meet with them again as part of the process. You should also explain to them that once you've prepared your meeting notes or your transcript from that meeting, that you will make a copy of those available to them, and that you are going to ask them to review that record and confirm that they are in agreement that they serve as a fair reflection of the key discussion points from that meeting. But I can't stress enough, good record keeping is absolutely essential. So during the investigation meeting itself, this again will form a bit of a checklist for you, but I always advise my clients if they're managing the investigation and I'm advising to make sure that they use open questions. So if you are acting as a background advisor, as an HR practitioner, work with the investigating officer to help them develop their line of questions and making sure that they've got a good mix of open questions but also closed questions. Closed questions can be helpful depending on what information you're trying to gather. Probing questions, again, really important. They're important for testing evidence, but again, we need to be mindful if we're asking probing questions that we don't come across as being aggressive. Feeling questions can always be helpful. They're not always necessary, but to give you an example, things that could be what concerned you about Jane Doe's behaviour, as an example, or why did you feel that you had to step in and intervene? Those are what we call feeling questions. That can help elicit kind of relevant information that will be, helpful to your investigation or fact-finding process. What else questions? So these are to make sure that you have all the relevant information. So it could be, do you remember anything else about the way, Joe Bloggs was behaving that morning? That can be really helpful to help you gain additional information that will be relevant to your investigation. It's really important at the end of your investigation meeting to summarise the key discussion points. So make sure you always end an investigation meeting with a clear summary, or I call it a roundup essentially, of what you have been told and what you understand you've been told. And that allows you the opportunity to seek clarification on any points with the person you've interviewed to make sure that you're kind of both on the same page essentially. So in summary of what I've just shared on this slide, open questions, closed questions, probing questions, feeling questions, and what else questions are a really good mix to have as you're developing your line of questioning. So I think that's really important. So coming on to the investigation report itself, this will be probably the most important document you're going to produce from the investigation process. I spent many an hour writing investigation reports. Some of the reports I've produced are anything from 80 pages upwards, depending on the complexity of the matter. Could be they're much smaller because you're dealing with a much more straightforward issue within your organisation. That being said, if the investigating officer has been asked to make recommendations, which is typically the case, and when I conduct investigations for my clients, I will always limit my role to being that of a fact finder, and I will make recommendations for the organisation to go away and consider. Now, it's really important that if you are acting simply as an investigating officer, which is the normal way of things, that when you make recommendations, they are simply limited to: have you found that there's a case to answer? Should formal action be taken, i.e. should the matter be referred to a disciplinary officer? Should informal action be recommended, such as mediation or further training, or should no further action be taken? Those are the limitations around the recommendations we make. So when I make recommendations to a client, once I've conducted an investigation, I will go through in great detail about my findings, and then I'll make the recommendations, i.e. I believe there's a case to answer and this matter should go before a disciplinary officer for them to consider. And then the intention is that my report and my coded evidence bundle will be passed to them for them to then review and make their own decisions. I make no comment about any sanction that should be issued or any decision making, because that isn't, that goes beyond the limits of my role as an investigator. The investigation report should be clear and concise, really important. It should also be objective when setting out the facts and findings from the investigation process. So I think that's another important point to note. Some top tips from ACAS include always avoiding the use of nicknames or jargon. So when I draft my investigation reports, I refer to people as Mr. or Ms. Or Miss. I do that intentionally because it removes a level of formality and it kind of gives a more impartial feel. So I think that's really helpful to the process. Obviously, might feel less natural if you are an in-house HR practitioner or you've got an investigation officer who is internal and you have a relationship with those individuals. But I often find it helps when you're drafting to have that kind of level of formality because it gives a more impartial feel to the process. Always use simple and appropriate language. Stick to the facts always. That's really important. Include all evidence collected. In my reports, I include that in the appendices, and I code my evidence bundle, so it's much easier when I'm working through that bundle and I'm referencing evidence that I have gathered in the main body of my report. It's much easier to go to a coded document essentially, and so if your report's going before a disciplinary officer, they can read the report and then you can signpost them naturally to the relevant document and they can dip in and out of that as they work through your outcome report. Explain any acronyms. If you're using them, make sure you explain them clearly so there's no confusion. And finally, what I always say is a good investigation report should have an introduction. It should outline the investigation process you follow to be really clear. Tell a story. I always think about if my report ended up before an employment judge, could that employment judge pick up my report and clearly understand what took place and why it took place? And so I think outlining the investigation process you followed is really helpful. You want to have a section for your findings. You absolutely want to have a section for your conclusion and then your recommendations at the end. But the investigation report, it's if you're not used to writing a report in this type of report, particularly if you've got a line manager handling the investigation process, that may be where, as HR practitioners, you're going to need to step in and support and help them. Kind of structure their thinking. Having a defined template that you use as a matter of course for your own organisation will be helpful to that process. But having an investigation report structured in this way will be really helpful to the overall process. I just want to touch on briefly, because I realised I included it at the start and I haven't covered it with you, it's just what to do if you're handling an investigation and the police are involved. Now, I've dealt with many situations whereby I haven't been instructed to conduct a workplace investigation into serious issues whereby an employee is subject to a police investigation for the same matter. And essentially, my position is always it's never helpful for an organisation to delay conducting their own workplace investigation for whilst waiting for the police to conclude theirs. A police investigation will typically take many, many months. A police investigation is very different from a workplace investigation, and the burden of proof is very different as well. And so, if you're dealing with serious issues and the police are involved and you're thinking about whether you need to, say, for example, suspend an employee, it's not going to be practicable for you or the organisation to suspend that individual and wait for the police to conclude their own investigation. So what I always say in a scenario where you have got police involvement is take advice, first of all, to make sure that you're clear on what you need to do next and to make sure that you are complying with UK employment law. But don't necessarily automatically assume that you need to put your investigation on hold. There's nothing wrong with progressing with your own investigation, but just be mindful that if the police are investigating, we just need to give some thought to. We don't want to prejudice their investigation, and essentially we just need to remind ourselves that a workplace investigation is based on the balance of probabilities. That's our burden of proof, so it's not beyond all reasonable doubt, which applies to a police investigation. And essentially, your investigation should allow you to make decisions about what you need to do to address any concerns you may have with an employee. That being said, sometimes these issues can be very complicated, and so I always suggest that if you're unsure about what you need to do, take professional advice, just to make sure that you can deal with issues pragmatically and also on a commercial basis. So that concludes our webinar for today. I've included on the slides, which I'll send out to Joe, a QR code. So if you want to join our mailing list, we do run various events. Feel free to sign up. And I've got all our contact details on the last page. So I'm going to hand back to Joe.
We've only got one question, Nathan. So if anyone has got any questions, please put them into the chat box. We do have time to cover questions, so please put them in there. So the question we've got is, Melissa has asked, what is the position if an employee raises a grievance, then goes off sick for months, then gets pregnant?
Well, I mean, if an employee goes off, if you're dealing with, it depends on the scenario of the grievance, I guess, really. But essentially, if you're dealing with a grievance and that person goes off sick, then what my automatic response is, can they meet with me while they're on sick leave? Because being unwell to attend work and being unwell to attend a meeting are two very different things. Very rarely have I ever seen a doctor or an OH advisor ever say to me that someone can't attend a 1 hour meeting, particularly when these meetings are often held remotely now. So my view is that reach out to the employee. Obviously, we acknowledge that they've gone on sick leave. We say to them, we're aware we've got this grievance. We're investigating your grievance. We would like to meet with you as part of the process. They may come back and say, I'm not well enough to attend a meeting. You could look to make a referral to occupational health to take a view on that. Or you could simply, and I often do this, will say to them, okay, if you're not prepared to meet with me, can I propose a series of questions in writing and ask you to provide written responses so that I can take that into consideration? Because ultimately, you're not going to want to leave your investigation into someone's grievance on the back burner for a number of months, potentially if they're going to be on long-term sick leave. Because the reality is, if you need to interview witnesses, for example, recollections will fade with time. So the passage of time can be unhelpful to an investigation process. So, my view is always to try and pin the employee down really and say, look, it's really, we want you to engage in the process. You've raised these concerns. We want to deal with them appropriately, but we're going to need your input.
Can I just ask on that point? I'm coming in as an independent, and the employee went off sick in July last year, and then raised a grievance in November, and the company has left it till now to do something because they already had another grievance, so it's already lapsed, and it's now
Right.
gone. They've gone to a solicitor, so they won't engage with the company at all. They've said they just want the solicitor to deal with it.
Yeah, I mean, look, ideally, you want to speak to her. I mean, she can instruct
Mm,
a solicitor and take advice, but my view is, look, I'm dealing with you. We're not, this is not a legal matter, it's an employment matter. And so at
hmm
this stage, you've raised concerns we want to investigate, and we go and we give her the opportunity to engage with us. If she willfully refuses and you've given her opportunity to meet with you, you've given her opportunity to submit written submissions for you to consider, and she doesn't do that, then what I would do is write to her to say, we are progressing with the investigation into the concerns you've raised because it's important to us that we do so. However, you're refusing to deal with us, which will mean that we will conduct an investigation and we will look to invite you to attend a grievance hearing at the end of that investigation so we can talk to you about our findings. But we need to be clear with you that our investigation process will not have the benefit of your input, and we don't feel that's in your interest. If
Does her being pregnant, because she's due in a few weeks, and they're worried, the company are worried that she might then use that against to say that the stress of it has kind of caused whatever, or
Yeah, well, I think what I would do is put the ball back into her court and say, look, we're really conscious that you raised concerns. We want to address them. Are you able to engage with us? Can you attend a meeting with us? If she says no, would you be able to put anything in writing to us? If she says, well, no, I can't, I'm not well, I'm pregnant, I'm heavily pregnant,
mm,
I've got to focus on that. I think we say to her, look, we respect that. We're going to conduct our own investigation, but we just need to be clear with you that obviously our investigation will not have the benefit of your input. But that being said, we feel that we need to do that fact-finding work to establish what may or may not have taken place. And I think, as long as you capture clear records of those conversations and those attempts that you've had to engage in the process, that's all you can do. I think it will be
mm.
more unhelpful to your client if they don't act and allow there to be a further delay, because I think they could be criticised for it. So if it were me, I would
Well,
say
that's it. They don't want me to contact her because they are worried, and I've said, look, it's not going to be, but they're worried that it could kind of come back on them.
yes. I think that I can get why they're concerned, but my view would be proactive,
Yeah.
contact, put the ball back into her court. She's raised the concerns. We can't unknow that she's raised a grievance. I think let's take the ball by the horns and say we'll investigate. And if she engages, amazing. If she doesn't, all we can do is conclude the investigation. Write to her once you've concluded the investigation and you've got your investigation outcome report and say, look, we want to meet with you at a grievance hearing, offer her the right to be accompanied, and say to her, we want to present our findings from the investigation and ask you to comment on them. And then what you can do is that you can then adjourn that grievance hearing and then consider any responses she shares with you before you make an ultimate decision. If she says no, I'm not well enough to do that, or I've just given birth and I've got my child, then you can say to her, well, look, we know what we can do if you're not able to meet with us is we will write to you explaining setting out our findings, and you can comment on them. And if she said, well, she's not able to do that, then it may be that you're going to have to write to her and say, look, we've not been able to meet with you. We've offered, and I would go through, say I've on this date we offered to
Mm.
a meeting you didn't attend, etc., etc. And then what you could do is write to her and confirm the outcome of the process and offer her the right of appeal, because by that stage you'll have exhausted every opportunity of engaging her in the process. So that would
Okay.
be my view. Does that help?
Yes, thank you.
You're very welcome.
Andy's asked, can the documentation, i.e., the suspension document, be shared?
Shared with who?
Doesn't say.
Does it- Let me
Andy, do
know
you
who.
want to speak or add another comment?
Yeah,
Yeah, can you hear me?
yeah,
Yeah.
hear you very well.
Yeah, just with me or the like whoever's on the call, because I think I agree with your advice because I think we have a environment where necessarily there's a bit of a knee-jerk reaction.
Mm.
We need to suspend this person, and I like your approach in terms of it being more uniformed.
Yes. Are you talking about the risk assessment?
Yes.
Oh yes, apologies. I think my letter. Yes, so I when I work with clients, I will share the when they clients will often say to me, "We've got an issue. We need to suspend," and I go, "Why?" Like what's
Yeah.
what we're worried about, and so it puts them on I think they put them on the spot sometimes because they can kind of go and so I said that
Yeah.
hesitation, that's what we need to lean into, because if we're not sure why we need to suspend, let's explore it. And so what we've done, we've developed a risk assessment tool, and we kind of, it's like a red, green, and amber, and we look at the risk.
Okay.
We look at the matter that we're dealing with, and we go, actually, what's the risk of this person staying in the business? So if someone says, actually, I think there's a risk of them tampering with evidence, that's almost like a red. We go, look, we don't want anyone to tamper with evidence. But it may be that actually you're dealing with something whereby we can say, look, we can move that person to a different team. We could
Yeah.
get some of their work duties temporarily, and that could help avoid them being placed on a period of suspension. I'm a big fan of, if I don't have to suspend someone, I won't. But if
No.
necessary, I will. But as you say, I try and keep it with, certainly when I work with clients, and certainly when I go back to my corporate career when I was in house, I like to keep things uniform because it made sure that we were consistent. So our
Yeah.
approach we adopted was broadly the same. So we didn't ever have any issues whereby people said, actually, you've treated me differently from other parties. We say, no, we have a standard practice and we follow that, as best we can, take into consideration that every situation can vary and be different.
Yeah.
But it's definitely something I would share with line managers. Have it as a standard tool that you use. Say ours is a bit of a tip box, and there's a little bit of an opportunity to put some narrative and information, so that if, for example, someone says, "Why did you suspend?" I can go
You've
back to
got it.
the form and say, on this date and time, if I'm acting as a background advisor, so I'm advising a line manager, I will complete that form. Both of us will sign it. But if someone challenges us, I can say, look, I met with Joe Bloggs on this date and time. This was the discussion points. These were the concerns, and this was the ultimate decision we made. Now,
Right.
employment judge may say, if we got that far, I didn't agree with the need to suspend. But my view is always, can I objectively justify why I took the decision I made, and stand by it? And as long as I've got the relevant information that I can rely on, then I'm always
You can
happy.
do
The
it.
problem I always have
Yeah.
is that sometimes I work with clients through no fault of their own, and I'll say to them, they'll say, I've got somebody. Sometimes we get instructed after the event, and they'll say, I've got somebody who's been suspended for 3 or 4 weeks.
Yeah.
And we say why, and they'll kind of give you kind of a top level view, and there's not much else behind it. And so I think it's a missed opportunity to capture information. For me,
Yeah.
I'm a bit, and I guess most of us will be guys who are HR practitioners. I'll be OTT about gathering as much information as I can, just so I've got that audit trail and that record
Yeah.
keeping. I hope that helps.
Okay. Yeah. No, that's great. Thank you.
No, you're welcome.
Paul has asked, if an employee submits a written email but
Mhm.
doesn't want it to be considered a grievance, can HR authorise an investigation?
Yeah, I mean, if somebody raises serious concerns, I see this a lot where we have I've dealt with a couple of actually recently for clients where you'll have an employee that will raise kind of serious issues, but say, I don't really want anything done about it. And what I will always say to clients is, look, you can't unknow information that is shared with you. And if the issues are, significantly serious, you're going to want to investigate those concerns. And it may be you have to say to that individual, look, with the best will in the world, you shared it with me. I can't unknow that, and I'm concerned to such an extent that we are going to investigate. Where we don't need their permission essentially to conduct an investigation. If they've raised concerns and they put it in writing to us, there's a clear record of that. And I've dealt with situations before where employees have said, I don't want anything done about it. I'm just letting you know. The client has said, okay, we'll respect that, and that's come back to bite them later on because they were then criticised. So my view is, if someone raises something in writing or even verbally, and I'm sufficiently serious, is sufficiently serious, and I'm sufficiently concerned about what's been shared with me, then I say to the party, I need to explore that further, and I kind of take that decision making out of their hands. Because ultimately, it may be that you've got other employees to think about who you need to safeguard, and if there's kind of suggestions around bullying or inappropriate behaviours or something that could be construed as sexual harassment, for example, you're going to want to be seen to be taking preventative steps to address those issues.
Okay, thank you. And Mina's asked, do you use AI to sense check and investigation report against the TOR?
You can do. I mean, I don't. We do use AI as a firm. I mean, we kind of, I suppose tentatively, we're not anti-technology, but I suppose we're, as a law firm, we're much more guarded around how we use it. But I don't personally, because I suppose once I've done the investigation, I'm so familiar with the evidence that I've gathered, and obviously when I'm building out my um, in the framework for my investigation, I always refer back to my terms of reference. So that investigation plan's at the front of my file, and whenever I open that file, I go straight to my terms of reference just to refresh myself on what it is I'm doing. It's really good because it keeps us focused as investigators on the issues at hand, and it makes sure that we avoid any kind of creep in scope or around the terms of reference. So, but that being said, there's nothing stopping you. AI is, I think the people who don't learn how to use AI effectively will be the people that will be left behind. So I'm not anti AI. The only thing I would comment on is making sure that if you are using AI, that you're not using any tools that are outside of your Microsoft tenancy. And what I mean by Microsoft tenancy is I mean the system that you deploy within your organization. So if you're running things through ChatGPT, that is a kind of a public AI tool essentially. And so anything you share in that is potentially a data breach. So it's a really important point to note. We use Copilot, sorry, as a firm, but that's an internal system. It doesn't go externally. It doesn't access the internet. It's been locked down. So just be very careful about sharing anything in any external AI tools, because you don't want to be in a situation whereby you have committed a data breach, essentially. So use any AI tools internally. So Copilot will be an internal tool as part of your Microsoft tenancy. So that's safe, and that's a tool that we will often use as a firm. But we're very cautious about anything external.
Thank you. And so another question, can a disciplinary hearing go ahead minus the employee being in attendance in police cases? Question mark. For instance, if the employee is jailed.
Well, I mean, I don't do much work with the police. So I'm not gonna hold myself out as an HR specialist for the police. I know they have a specific framework around, I believe, around how they handle disciplinaries. But I have held disciplinary hearings in where the respondent is absent. We've held it in their absence essentially. But in my scenario, they refused to attend. We invited them multiple times. So yeah, there are circumstances when you can hear a disciplinary hearing in somebody's absence. But my preferred position is always to try and get that person to engage and attend at every opportunity. So I will often, my magic number is 3. If someone doesn't attend the first hearing, I will always go to, I'll reschedule and invite them a second time and then a third and final time before I make a decision to hear something in their absence. Yeah, the challenge you're going to have is if someone is they've been arrested, for example, and they're not able to attend, then yes, you're going to potentially have to hold that meeting in their absence. What I always suggest is take professional advice, because I think that's always helpful just to keep you safe and mitigate as much risk as possible. But yeah, potentially if you've got someone who's physically not able to attend, you're going to have to make a decision about what you do in those circumstances.
Emily's asked, what do you do if an employee raises allegations, for example, in a grievance that are historical, for example, 3, 5, or 7 years? What is reasonable in this case in terms of limiting the investigation? Is it reasonable to have to look into that?
It's a really good question, and actually, I'm not a big fan of looking at things that are really, really historic. Um, if someone, it depends on, I guess I'm going to sound like I'm sitting on the fence here. I will say it depends on the issues that are being raised. So if someone is bringing current issues but referring to historical issues, maybe around patterns of behaviour, if it's something related to, say, sexual harassment, for example, I would do my best to maybe explore and investigate, adding in a caveat to that individual raising the concerns that with the best will in the world, anything that's, typically I'd say anything older than 6 months, recollections are going to fade. They really will. And it will mean that the quality of evidence you gather may not be very helpful. That being said, as we all know, there is a duty on employers now. I'm going to focus on sexual harassment as a good example. There is a duty on employers to take preventative steps to prevent sexual harassment taking place in the workplace. So if someone comes to you and says, "Hey, I've been subject to these inappropriate behaviours. I feel I'm being sexually harassed. These behaviours, they're not new. It's occurred before," and they suddenly say, "Well, actually, it happened 3 years ago." You would want to, make efforts to look into that, and it may be that your efforts to look into that, return an output of people can't remember an incident taking place, but at least you can demonstrate that you've taken steps within reason to fact find. But if someone just comes to you and raises, an issue or concern about something that's, 2, 3 years old, realistically, you're going to have to sit with the individual, I think, understand what's brought about them raising the concerns now, but managing expectations around, well, look, these issues happened 3 years ago. Realistically, we're not really going to be able to do anything with it. But again, think about the issue that's being raised and take a view and take advice. I always say that. I say to my clients now, if they have any kind of odd kind of issues that arise, pick up the phone to me and we can take a view together to make sure that you're best placed to mitigate as much risk as possible. I think the challenge we have as HR practitioners and business leaders today, people are much more litigious. I'm not sure whether you all feel that. I certainly see that in my work. People are very litigious today, and things can become, complicated very quickly. I have clients who, simply want to have conversations around performance management with employees with the aim of helping the individual, improve. And those conversations can escalate really quickly because people, now don't want to have, conversation around their performance and they jump onto AI. For example, I see a big uptick in grievances coming in where it's clearly been drafted by AI. They're kind of obvious clues and patterns of the way things are worded, which you can clearly see is being drafted by a chat GPT kind of software. And that can make it more complicated. But I think that also makes people much more confident in raising issues that are actually much more complicated than they need to be. So yeah, it's a difficult climate, I think, for employers, certainly.
Michelle's asked, if you're about to carry out an investigation and the employee lodges a complaint against the line manager relating to the incident under investigation, should this be dealt with via the investigation process or a separate grievance?
Are we talking about overlapping matters? Sorry, Joe, just so I understand.
Yes, yeah,
think
they
it
are
sounds-
overlapping.
All right, thank
Are
you.
they?
Thanks, Michelle.
Okay, so Michelle, I'm going to ask a couple of questions just so I make sure I'm understanding you correctly. And is the line manager the one that was conducting the investigation originally?
No, so the investigation's not started yet. So the
Okay.
investigation surrounds how the employee has been disrespectful and swore at the line manager. But we believe we may get sort of a counter complaint saying, well, I only swore at him because he spoke to me inappropriately or disrespectfully. So I think it can be picked up in the investigation, but we're not sure whether to sort of separate them because it is all connected.
Yeah, I mean, look, I would deal with them concurrently, and if they're that closely connected, I would deal with them. Investigate. If there's a counterclaim, obviously investigate that, and then you can take a view on both issues. But as you say, I see this a lot. You'll have somebody raise a claim against the line. The line manager might raise a claim against an employee. That employee counters. There's so much overlap that I always say deal with it concurrently. Don't delay one over the other, because actually the information you gather is probably from dealing with one issue will help you with the other issue. So my advice is deal with it concurrently, look at what the evidence tells you, and then make decisions. And it may be, and I've dealt with situations like this where actually both parties have ended up being subject to disciplinary proceedings because it was found through the investigation process that they both acted inappropriately towards each other. Sometimes mediation can often be a good recommendation, but if the conduct is significantly falls short of the expected standards that you would expect as a management team, then yeah, nip it in the bud and deal with it through the disciplinary procedure.
Thank you.
You're welcome.
Right, Paul has asked, if the investigation officer suddenly gets scared of being victimised despite being reassured by HR and makes a recommendation that there is no case to answer, it is obvious that there is, in brackets harassment, a case to answer, can HR bypass the investigator's recommendation and proceed with disciplinary?
Yeah, I think if you have genuine concern about the findings from the investigating officer, it may be that you want to instruct another party to review the investigating officer's investigation and see whether they concur or whether you reinvestigate. It may be that you investigate. It depends on the level of concern, I guess. I mean, hopefully, we know if you're managing the process kind of effectively at the outset, you'll make sure you instruct somebody who you are confident is going to be able to do that process justice. But again, yeah, if you've got concerns that there is clear evidence that suggests there is a case to answer, then I would be sitting with that investigating officer and saying, it's not about applying undue pressure, but we are concerned about your findings because the evidence clearly suggests X, Y, and Z. What I wouldn't do is unilaterally say, I'm going to ride Russell over. Not suggesting you would, but that's the kind of that's potentially the challenge, right? Is a respondent will say HR rode Russell over the investigating officer because there was a clear intention for a preferred outcome. So what I would suggest you do is, if you have those concerns, is that if you're satisfied that the evidence bundle is a good evidence bundle and we've got no concerns about the quality of evidence that's been gathered, you can then pass it to another investigating officer who is completely independent and ask them to review that bundle and see what outcome or recommendations they make, and then go from there. What I certainly wouldn't necessarily do is unilaterally. I'm just thinking as I'm talking to you, I wouldn't unilaterally just say no. I disagree with your decision. I'm going to make the decision that it goes to a disciplinary hearing, only because there will be a counterclaim or an appeal that will say that HR applied undue influence, or they essentially rode roughshod over the investigating officer and ignored the recommendations made. Bearing in mind, the investigating officer isn't a decision maker ultimately, but if they were to say no, there's no case to answer. We said, well, actually, we disagree. I think that belt and braces. Make sure that you get somebody else who isn't a decision maker to look at it and see whether they agree with the findings of the investigating officer. That being said, if you don't have that that management infrastructure and you feel like actually we've got a small management team, we may need to make that call. You'd want to absolutely objectively justify why you disagree. With the matter not being referred to a disciplinary, with the matter, not being referred to a disciplinary hearing, and capturing that in your own record. So if someone did challenge, you could say, well, actually, we looked at the evidence and we weren't satisfied with that recommendation because of X, Y, and Z. So it's about being able to objectively justify your decision making. I hope that helps.
There's a few more questions there.
Yeah, of course.
Time. Right, Trace has asked, in a small organisation where there are a few people, i.e. under 10, and there is a complaint and the issue is with the founder, what would you recommend from an investigation perspective?
I mean, in those circumstances, this will always factor on cost, I guess, and the financial position of the organisation. But my view is, and we do have some smaller clients. I always say if it's complaints being made against a founder, there's no other management colleagues at that level who could essentially challenge. You're almost looking for, if you've got a founder, you want to have at least somebody else who could potentially do the investigation who's of a similar level. I would recommend it's outsourced. And the reason I say that is because if it's outsourced, you bring in a level of independence, which I think is always helpful. Things that I would weigh up is, what's the nature of the complaint, length of service of the employee concerned, are there any exceptional circumstances that we need to be, concerned about, discrimination, for example, disability discrimination, whistleblowing, grievances, all that sort of stuff that I would risk assess. But I always say to smaller organisations, it's often really helpful to outsource that work because it removes kind of any issues around, it not being impartial or there, having one person deal with investigation and potentially a disciplinary. That being said, employment tribunal will take into consideration the infrastructure within an organisation, and so if it's a small organisation, they will accept that it's not always going to be possible that there are separate parties to deal with the different stages of a process. So but my view is always there are HR consultants out there who will always happily pick up and support an organisation, and my advice to a client is go and get someone independent to deal with it, because I think it will safeguard you later on.
Thank you. In an Ofsted regulated service, which process takes precedent when a safeguarding concern arises? Referral to the local authority designated officer or the organisation's internal investigation procedures? And they've said because there's often a conflict between operations and HR.
I mean, if you've got safeguarding concerns, you want to speak to the ladder. You definitely want to make a referral to the ladder. I would never delay. I would run the two, at the same time. So when we do a lot of work with schools. I sit on a board of a school as well. So so if there are safeguarding concerns, that will often go to the ladder. And actually, that can be really helpful sometimes to a process. I've just dealt with a situation recently whereby we've had to dismiss an employee. They had length of service, but we had to deal with it very quickly because the ladder actually came back and said, this person, it cannot work in your setting. And so that was really helpful. So my view is I wouldn't, if you've got genuine safeguarding concerns, that's significant. You should be referring them to the ladder.
Sorry,
you stop. Sorry, go on, Nick.
Yeah, I raised the question. I was just perhaps my question wasn't phrased as well as it could have
Oh,
been.
apologies.
So we have situations where the manager just automatically refers to Lado within the set period that they've got to refer.
Mhm.
And then what they say is that we can't move forward with the disciplinary investigation because they want to see the outcome from Lado. And then
Mhm.
what possibly could happen then, it could be weeks pass before Lado make a determination on whether there's, the safeguarding concern stands, as it were.
Mm.
So we're often in conflict with the managing
Yeah.
operations. So it was
Yeah.
just, I think they should run concurrently.
I agree.
Uh,
Yeah, I would
right.
agree because ultimately, and I think if you've got, you know, certainly if I'm working with a school, so in a school setting, the schools that do this really well, the schools that have really well defined policies and procedures, and so it can be that if you've got a safeguarding issue, you're going to want to refer that to the ladder. Absolutely, you're going to want to make sure you comply with your timeframes and all that good stuff that we know about, but also you're going to want to investigate because it may be that actually they're breaching clear policies and procedures you have internally as well that you're going to want to address. So for me, it's very much a concurrent process. So I do see this sometimes where you get line managers, certainly if we're advising, will go, I've gone to the ladder and we're going to wait, and I'll go, actually I wouldn't be waiting, I would want to investigate, because again, the passage of time is really unhelpful to fact finding. And once you've got 4 or 5 weeks down the road, some people sometimes do say, so I don't quite remember it, or from what I can remember, you want to deal with things as quickly as you can. But again, I always say to all of our clients, anything complicated or you're not sure about, just take professional advice. Absolutely take professional advice. But yeah, I would deal with them concurrently. That helps.
Okay.
Paul has asked, if the grievance results to disciplinary, are we supposed to inform the claimant about the disciplinary outcome?
No. So if you're taking action with a respondent, that whatever action you take, including outcome of the any disciplinary proceedings, that's between you and the respondent. All you can say to the claimant is that if, for example, this has come to light through a grievance, you can say their grievance has been upheld and that the organisation is addressing its concerns with the respondent directly, and there ends what you can share with the complainant, because ultimately whatever sanction you issue is between you and the respondent, not the complainant. And I know complainants can often feel aggrieved and they want to know what was done and what level of sanction was issued. But actually, with the best will in the world, that is private information. And it goes, outside of the information that they need to have. All they need to be told is that we've upheld. I'm thinking of a grievance scenario when I say this. All they need to be told is we've upheld their grievance and we're taking formal action in line with our policy and procedure.
There's just two more quick ones now.
Yeah, go for it.
Hopefully they're quick.
That's
Jaws
right.
asks, if an individual does not want to raise something about a senior person due to power imbalance, can we break confidentiality or not, especially regarding SRA wellbeing rules?
Well, again, it will depend on the nature of the issues being raised, because it's very difficult if you become aware of something taking place, of unknowing that information, essentially, right? So if someone is raising, say that they feel they're being bullied or harassed, or there's some kind of alleged inappropriate behaviour that could amount to sexual harassment, for example, you're not going to be able to unknow that. And even if the person bringing those issues says, I don't want this to be dealt with, you're going to have to make a decision as an organisation about what you do to deal with those concerns. And if you feel that you need to take preventative steps to address those issues, you're going to have to say to that person, I cannot unknow what you've shared with me, and I have to take steps, particularly if there is concern that this could happen to somebody else. And so my view is always to an employee. Often I'll have employees, certainly when I was back in corporate life, I'd have employees that would come to me and would say, can I speak to you confidentially? And my default position always was, it depends on what you're going to share with me. Everything we discuss, yes, it's confidential within the realms of, I'm not going to discuss it, with inappropriate people. But if you raise issues or concerns, it may be that I feel duty bound to do something about that, and I put them on notice of that. I never say to somebody, "Yeah, that's fine. Of course, you can talk to me on a confidential basis," because we automatically assume as HR practitioners, of course, everything we do is confidential. But I manage expectations, at the front end really, and say to somebody, "Yes, you can talk to me, but it depends what you're going to share with me, because I may need to do something with it." Really important. And I certainly go back to my corporate career early on. I've had my fingers burnt, certainly once, where someone shared something with me and they didn't want us to do anything about it, and we really tussled with it, and we decided to leave it be. And we said we'd check in with that person, which we did. But then further issues, occurred, and then I was criticised for not dealing with it. But actually, all I was doing was honouring the person's wishes. And what I learned from that scenario is actually sometimes it's best to say, look, I can't know what you shared with me, and I need to act in the interest of the organisation and for the person bringing the concern, and for any other employees that could be at risk.
I think this is sort of similar to what we've just been talking about, Nathan. Shirley's asked, what would be the advice if there is a concern with bullying and victimisation coming from a director?
Oh, I mean, again, it needs to be addressed, regardless of the seniority of the person. If there are concerns of bullying and harassment, you need to address that. Hopefully, you'll have a bullying and harassment policy within your organisation, and then you can follow that process. But essentially, if you don't have, in the absence of a policy, if someone raises concerns, you need to investigate. If it's about a director and you've got you're a larger organisation and you've got a sufficient management infrastructure, then hopefully you'll have other directors who can take a lead on investigating, or you could have maybe a senior manager who does the investigation, because ultimately they're not a decision maker, they're a fact finder, and then that investigation, the outcome or the output of the investigation, can be referred to another director who maybe is appropriately senior enough to deal with that scenario. Oftentimes I will deal with clients whereby they have director level, executive level parties, and that gets outsourced to me, and I will then deal with either the investigation, and it will go, and the kind of the disciplinary aspect will go back to the organisation, or more commonly when it's at exec level, the disciplinary comes to me. They will do their own investigation and outsource the remainder of that to me, for me to then deal with that kind of director level individual. Always should be dealt with. Think about outsourcing it if you're a smaller organisation, or sometimes even if you're a larger organisation, can sometimes be helpful to outsource and gain a level of independence. And obviously, whatever you do, check your policies and procedures. If you've got a contractual disciplinary procedure, follow it to the letter, because you don't want to claim for a breach of contract claim. So that's really important. Hopefully, your disciplinary procedure will be non-contractual. That's the preferred position, because it gives you a level of flexibility. I'm not suggesting you should just willfully deviate from your policies and procedures without good reason, but I say that, the contractual piece that I've mentioned, I say that intentionally, because we have clients who have contractual policies, and that sometimes will limit the scope of what they can do. But ultimately, if you can outsource, then outsource and deal with it that way. If you've got the infrastructure in-house, then make sure that it's dealt with regardless of the seniority.
That's great. Thanks, Nathan. There's no more questions, just lots of good comments about your delivery, so well done.
Oh, thank you very much. Very nice to meet you.
Right, so we'll send out some correspondence to everyone that's signed up this afternoon. So if you'd like a copy of the slides or the recording, then please put a comment against the LinkedIn post. Our next event is on Tuesday, the 28th of April, and is called Aim High, Navigating Difficult Conversations. A link to sign up for that will be included in the email. If anyone is recruiting, we've got FD recruit, exec recruit, charity recruit in the group. Otherwise, I'd just like to say a massive thanks to you, Nathan, for your time and putting it together. And thanks everyone for tuning in. Thank you.